and 6 other co-conspirators, including Don Lemay, all indicted for the both counts. And Judge Miko, Keith Ellison's married wife, judge's wife works for Keith, said that there was no FACE Act violation. So the judge was wrong again. Grand jury said, oh yeah, that's pretty clearly a FACE Act violation because these judges are partisan hacks. Now here's their argument. They say, we're doing everything appropriately. Do not order us to give her phone back. We're still processing it. Saying the court, another judge called Shannon, properly issued a warrant that authorized us to go get this phone. We followed the Fourth Amendment. We followed the rules of criminal procedure. And because Nekima's motion to quash this was filed before an indictment, okay, there was a criminal complaint, the affidavit, judge accepts it, she gets charged, she files the motion, then the indictment by the grand jury comes back down later. They say, you should meet this with caution and restraint because the grand jury just validated everything. Now, defendant Nekima appears, and Don is going to make a lot of these same arguments, Nekima appears to argue that the warrant should be quashed because the contents of her phone, she submitted this, in quote, are irrelevant. Like, oh, all right, thanks for telling us. We don't need to look at your phone because there's no evidence of a crime there. Thank you, Nekima. Wow, that makes our job a lot easier. All right, live stream's over. See you guys. And it's unlikely to contain any material evidence of a crime. That's the other allegation. Okay, no one believes you, Nekima, at all. But they are citing a Supreme Court case. They say, no, that's not the standard. We don't just listen to criminally charged defendants and take their word for it. They say probable cause is not a high bar at all. It's very low. Like more likely than not, like 51%. Yeah, there's a reasonable person thinks there's evidence of a crime there, or a crime has been committed. And the affidavit submitted in support of the warrant easily cleared that bar, and a judge signed off on it. The warrant declares that the defendant, Nekima, used her Instagram and her account to advertise the entire operation, Operation Pullup. She's banging it out on Insta. The agitators' name for their planned disruption of these services. And in addition to that, they also described Operation Pullup as a clandestine operation wherein she and other agitators, quote, disrupt business as usual. She used her phone to encourage 30 to 40 agitators, including Don and his people, to ensure that they had city's church address. And this will be interesting. Did Don Lemay just look on Instagram and he's like, oh, wow, this is curious. Let me just go poke around over there. Or was there active conversation between the two? Were there text messages? Were there DMs? Did Don's team reach out to her team? Did they get the information so that they could join them in the prep planning at the parking lot before they attacked the church? We'll find out. She also encouraged 30 to 40 agitators to spread out and avoid wearing identifying clothing once at the church. They entered the church, they led a chant, they actually disrupted religious worship, preventing the delivery of services. If you do that to an abortion clinic, if you stand in the doorway at an abortion clinic and you prevent the receipt of those services for 1 minute, they'll want the death penalty for you. How dare you interfere with their Eucharist? Entered the church and led a chant, and then gave a video interview while literally standing inside the church. All of that documented very clearly by Timothy Gerber. Thank you, Timothy, the affidavit of the agent. And so the affidavit that was submitted to the judges established a fair probability that contraband or evidence of crimes will be found on her cell phone. Low standard. United States versus Gator. There's a fair probability that we'll see it, which is like such a low standard. Yeah, it's pretty fair. There's probably something on there. You think so? Yeah, that's fair. Yeah, that's fair. Specifically, the phone is likely to contain evidence, which I'm saying that the standard is so low, they just can get it. Specifically, the phone is likely to contain evidence, including messages, between the defendant, Nekima, and other agitators like Don Lemay, demonstrating that they conspired to enter the church. They conspired to disrupt these religious worship services, and they physically obstructed congregants and clergy, getting in their faces, the guy to back up because Don's breath was in his mouth. Now, Nekima complains that the authorized search of her phone, if you look into there, she says And what she's trying to do right now is create a roadblock. So right now, the prosecutors have not read it. They just admitted that. They haven't seen any of the evidence. She's trying to cut that off at the pass, make sure that they can't see it and use any of that evidence. She says, why? Why can't they see it? Well, it's going to violate her privacy and her constitutional rights. But we're not violating any rights. The search warrant already balances all of these concerns. We balance, the judge balances it. This is why we don't write search warrants for ourselves. We go to a judge to get it. The judge says that they balance privacy-related and law enforcement-related concerns. The judge did that. The warrant appropriately provides that while the United States, the judge was careful, while they may review all records that relate to the violations of these two sections of the law, the United States, quote, the judge said this, must make reasonable efforts to avoid searching files, documents, or other electronically stored information which is not identified in the warrant, and establish a search methodology to ensure that no attorney-client privilege communications will be inadvertently reviewed by the team. So the judge is being very cautious. Now, the defendant, this is the DOJ writing, says that Nekima seemingly concedes that if necessary protections are implemented, then a search of her phone is permissible. So why is she filing this motion to get it back? They explain, consistent with longstanding DOJ policies, we're going to have a separate filter team. We're going to have attorneys, federal agents, forensic examiners. They're all going to look at her phone. They're not going to tell us anything or disclose any privileged documents or any communications to anyone involved in the investigation or prosecution of Nekima. And of course, we saw what they did with President Trump. Did Trump and his defense team, like Evan Corcoran, his attorney, get all of the benefits of attorney-client privilege? No, in fact, not at all. DC judge called Beryl Howell it eliminated their attorney-client privilege and used this concept called the crime fraud exception to do that, saying if you're a lawyer, you don't just get total immunity against any inquiry. If you're committing a crime, then your attorney-client privilege is breached. So the judge Beryl found that against Trump. I don't think they're going to find that here because these are much more favorable defendants, but they could, is the point. And maybe we'll get there. Now, the use of the filter team has been approved. We've done this many times. 9 federal courts of appeals have all done this. And so she is legally wrong. We promptly and appropriately created a filter team. And notwithstanding her histrionics, great word, her kind of, theater kid, acting, screaming, whining from the rooftops, ranting about a fascist offensive and a supposedly politically motivated prosecution. Despite all that, insanity, the government went and got a search warrant. Okay, there's rules that say how to do this. We did that exactly. We're also conducting a review of the cell phone. We have a filter team. They've been instructed to respect attorney-client privilege and to seize only those items the judge said we could get. And so as soon as we're done, we're going to give her phone back anyways. Her motion for a return of property should be governed by equitable principles and should be dismissed if an adequate remedy at law if there is a remedy at law or if they cannot show irreparable injury. She's not going to be irreparably injured. She is now requesting something extraordinary. The case is still developing. She wants us to give her her phone back before we're even done with it. And this fails to satisfy the requirements under the law. There has been no violation of her constitutional rights at all. In fact, a federal magistrate judge determined, yep, there's probable cause to go get that cell phone. The warrant explicitly authorized the search and seizure of the phone for the records that we're searching for. And as to the third requirement, her motion, Nekima's, also contains no facts at all that she's somehow going to suffer irreparable harm if she doesn't have her cell phone like right now. We're doing our search. She's going to get it back when she's done. We're done. Now, the government recognizes that we have no right to hold on to a property that is not contraband indefinitely, but we've already explained this. In fact, in the affidavit supporting the search warrant for the phone, we've explained explicitly the United States will return her phone once we determine it's no longer necessary to retrieve and preserve the data. We're going to make every effort to do this quickly and get it back to her. And once the search is completed, the government proposes the phone can be returned if she stipulates as to the authenticity of a forensic copy of the phone. so that the government may ensure that it can use any of the data seized from the phone for the purpose, any purpose at trial or any other hearing now that she's been indicted. And that's very smart because you don't want Nekima to get the phone back and then you've got a copy of all the stuff that was on the phone. And then Nekima turns around and says, wait a minute, that evidence that you extracted from my phone is invalid. You perverted it. You manipulated it. You changed it somehow. They'll say, well, if you're going to make that argument, then we're going to keep the phone so that we can bring in an expert to say, no, actually the phone looks like this. The data looks like that, and they match. If you give her the phone back and now she says, actually, my phone is like this and your data is like that, then you're out of possession of that physical piece of evidence. But they will give it back to her as long as she confirms that this little set that we've extracted here is authentic. If you don't want to say it's authentic, that's fine. We'll just keep the phone. And then we'll use the phone to prove that it is authentic at trial. But if you want it back, we'll give it to you, but you got to confirm that it's real. And then you can't make that argument down later after the fact that it's actually corrupted or perverted or whatever. And so for the foregoing reasons, we ask that you deny Nekima's motion for a temporary order halting any phone search. That was her main argument. Halt the search. Don't look at my data, because she knows that it's damning. And even if she deleted a bunch of stuff, they're probably going to go find it. The J6 alleged pipe bomber, they're backtracing that thing. That guy allegedly deleted his entire phone, wiped it like 900 times. And they've got evidence of that. And so we'll see what they've done. And if they've gone on a deletion spree, that's going to be pretty good evidence and indicia that they're trying to cover up their crimes, and the DOJ will get their hands on it. So that motion is now out. Nekima will respond to that, and then the judge will issue a ruling, but she's also trying to modify her release conditions. She was put on pretrial services, and others apparently have been released on their own recognizance. Having pretrial release, man, you got to check in with somebody. There's extra rules you have to follow. And she doesn't want to do that because she's Nekima. She can do whatever she wants all the time with no consequences, or at least she thought. So she submitted a motion to modify her release conditions, right? You're arrested, taken into custody. Judge will do an initial appearance, determine, are you a danger to the community? Are you a flight risk? What are the nature of the charges, and so on? And then decide what to do. Release you on your own so that you can just go free on your own recognizance, or do you need to check in with somebody and have a little bit more monitoring? So she said, let me go free. The DOJ said, no. They say Nekima has moved to